Let me try to just quickly go through the agenda I'm going to try to do today. I did talk about the Frightening and High article last year, and I know you all weren't necessarily here last year carefully taking notes that you've reviewed before today, but and so we'll go back to it some, but I want to talk mostly today about the progress that I think we've made since last year and actually over the last several years, and about some pending cases that I'm involved in. But I will first start by going back to the beginning, going back to Smith v. Doe. It's a 2003 decision of the US Supreme Court, and it held that Alaska, which had recently at that point enacted its registry law and a kind of primitive version of the website that we're all familiar with. It existed then, not quite as fulsome as they've become. But the Supreme Court there said that it could be applied to people who had committed their offense before the law was passed, which normally you can't do that if something is punishment. You can't punish somebody, you can't pass a law punishing somebody for something they did before you passed the law. That's a violation of what's called the ex post facto clause in the Constitution, in the federal Constitution. But the Supreme Court said that was no problem here because the registry was not punishment. It's a civil measure, kind of like a building code, you know, reasonably designed to protect public safety. Why is it reasonable? Because, and this is a quote from the court, the legislature's findings are consistent with grave concerns over the high rate of recidivism among convicted sex offenders and their dangerousness as a class. I'm going to be coming back to that, you know. And then the famous phrase, the risk of recidivism is frightening and high. And they then cited a study that they had cited before that claimed that the rate was about 80%. But there are really two key thoughts here. One, that there's this dangerous high rate, but the other is that you can talk about sex offenders as a class. And that, I think, is equally important. So how do we undo, how did we undo? I think we've actually made a lot of progress undoing that legacy. The two assumptions, I think, are the foundation of every bad rule that's followed since. So, I mean, they're really important. And we're going to take them in turn, and I'm going to also talk about some conceptual threads that are connecting some of the recent cases. So that 80% figure, that was the basis of the claim of frightening and high, came from a Justice Department manual. The Federal Department of Justice wrote this manual. But if you look in the manual, they didn't do any work themselves. They were just citing things. And for that statement, they cited one item only, an article in Psychology Today, which had been published in 1986. So David Feige, who was once a public defender and became a documentary filmmaker, he recently did a short little piece I'm going to show you, about 8 minutes long. And in that piece, he interviews Robert Longo, who wrote the Psych Today article, and Barbara Schwartz, who wrote the Justice Department manual that quotes Longo's article. And so we should be fair and hear what they have to say. I think actually you'll enjoy it, especially if I can make this work so that you actually see it. Let's see. No, that didn't. I have an alternative method. Okay.
What I think we ought to do with pedophiles, the way I think you ought to punish them is I think you ought to lock them in a room with the parents of the child and hand the parents ball back. No windows, and give the parents half an hour. And then whatever's left, you can shovel up and throw out the garbage.
You shouldn't be a teacher, you shouldn't be in politics, you shouldn't work at McDonald's.
It's not if they reoffend, it's when will they reoffend. And I don't want to take that chance.
State passed 4 bills on the first day of session, designed to make the Sunshine State the most difficult place in the country for sex offenders.
Governor Cuomo has signed legislation that prohibits registered sex offenders from becoming firefighters.
Megan's Law will protect millions of families.
In a few moments, I will sign the Adam Walsh Child Protection and Safety Act.
President Obama signed the International Megan's Law bill into law on Monday.
The sex offender registry and other things that are imposed on sex offenders are justified by the fact that they have a frightening and high reoffense rate. As high as 80% of sex offenders reoffend. And that's a frightening and high rate. If 80% of sex offenders reoffend upon release, that would be frightening and certainly very high.
There is a huge disparity between the public's perception of sex offenders and the truth, the empirical, scientific, actuarial truth.
In explaining this frightening and high reoffense rate, Justice Kennedy made reference to a manual published by the United States Department of Justice. The Justice Department manual cites only one thing, an article in Psychology Today, a mass market magazine from 1986. It has no backup data. It has nothing in it that it cites. It's just 80%.
I began working in the field of treating sex offenders in 1978. When I started in the field, there was around 30 or 40 of us. We'd have a conference and we'd all attend and we'd all present. It was a very small world. I work with some of the most dangerous offenders, measuring their sexual response to what we call deviant stimuli with a device called the penile plethysmograph. So if they were getting aroused, we would give them a little shock. We were highly criticized for what we were doing. We were compared to a Clockwork Orange. We wrote an article for Psychology Today that described what we were doing. In that context, we felt it important to say the studies all over the country that had been published to date, and this is back in the 80s, ranged from very low to very high recidivism rates, as high as 80%. That got taken to say all sex offenders recidivate at 8%. That's absolutely incorrect. It's wrong. It's not true. If you're going to base laws at a federal level, you don't cite popular psychology magazines, no matter who the author is, me or anybody else. It's not a scientific journal. I'm appalled that this could happen. This is not my intent. Not my intent at all.
In 1988, I was given an assignment by my employer to research sex offender programs around the country. I couldn't find any, so basically I just made up a model. My original research paper had 6 references, including the dictionary, and the paper that Rob Longo did for Psychology Today. The best we were doing was just making a bunch of guesses, but it's there now. There is hardcore, scientifically based research.
The recidivism of sex offenders has been studied over and over and over again. One of the most comprehensive studies of recidivism found a recidivism rate among those almost 10,000 sex offenders of 3.5%. There's a study in Maine that had a rearrest rate of 3.9%, A Nebraska study found a 2-year recidivism rate of 1.7%. 1-year recidivism, 0.6%. These studies are quite consistent. Criminals of other sorts, property crimes, drug crimes, have higher recidivism rates than sex offenders.
Why would you go to the first things that were ever written when there have been thousands and thousands of articles written since that time? That is deliberate indifference.
There's no doubt that the statements about reoffense rates are wrong. They're just, as a matter of social science fact, those statements are wrong.
At this point, the phrase frightening and high has been cited in close to 100 cases. Legislatures routinely recite it in their preambles to their legislation. They cite to the U.S. Supreme Court, which rested its assumptions on nothing.
We've designed these draconian sex offender laws, telling ourselves that the people who are affected by these laws are monsters, the other. The reality is these laws, by severely limiting the ability of offenders to get housing, to get jobs, they're undercutting the ability of the society to reintegrate sex offenders and prevent future sexual violence.
You are now classified as a sex offender. You have been kicked out of college. You're not allowed to use the internet. You're not allowed to live with your dad because he lives too close to a school. Do you think that the punishment fit the crime?
You're throwing thousands of people onto the streets, out of their houses, out of school, based on frightening and high, decades of recidivism, 80%, which came from nothing.
What they're saying is they're very dangerous, they're going to hurt us. This fear is exactly the source of these policies about public parks, about libraries, about residency restrictions.
It should be worrisome to all of us to see the protections of the Constitution cast aside because today we're frightened. The question is, what kind of measures do you take to secure yourself against these risks, and at what cost to your society and your values as a society?
Okay. Feige's really good. I mean, he just does a great job with this. And at the end, it says, well, the Supreme Court's going to reconsider it. And they will reconsider it one day, but they're not just when he thought. But it will maybe be coming up this coming year. When the notion that they're going to reconsider it, he wrote that when this case was thought to be on its way to the Supreme Court. It's a case called Doe versus Snyder, 2016. The Sixth Circuit Court of Appeal. So courts of appeal, okay, this is better. Courts of appeal are the intermediate federal level between trial courts and the Supreme Court. And there's a bunch of them around the country, geographically dispersed. Here in California, we're in the Ninth Circuit. The Sixth Circuit is the circuit that governs Michigan and some of the Midwestern states right by it. And in Doe v. Snyder, what the panel there held in a unanimous opinion written by a very conservative judge, especially a conservative on criminal justice matters, Batchelder is her name, that the Michigan Registry imposed punishment, and that these things that had just been added to it, term extensions, that is extending how long people had to be on it, reporting requirements that were made more onerous, additional exclusion zones, residency and presence restrictions that couldn't be applied retroactively because it was punishment. This is, in 2016, the Sixth Circuit Court of Appeals. And they said, well, Smith's wrong. And they said the overall rate isn't so high. The restrictions are arbitrarily imposed on all residents. This is an important point. There's no individualization. There's no inquiry into whether the people being subjected to these rules in fact pose a risk. We're just putting it on all of them. And they said, anyway, there's no evidence that the things work anyway to advance public safety. So this is the Sixth Circuit Court of Appeals. So clearly, when they reached that decision, well, first, how did they deal with Smith? I mean, they had this case. The U.S. they're supposed to follow the U.S. Supreme Court. So what do? Well, they said, and read this, the record below gives a thorough accounting of the significant doubt cast by recent empirical studies on the pronouncement in Smith that the risk of recidivism is frightening and high. They just said, well, there's been a lot of work done since 2003, and what the Supreme Court said in 2003 isn't right. This is a really critical thing. Well, Michigan, of course, asked the Supreme Court to review this. And everybody thought that the Supreme Court was going to take that case, which is why David made this little snippet. It was actually a New York Times video, a sort of a video version of an op-ed piece. He did that for the Times. The Times actually put it out on its website. But the Supreme Court said, no, we're not going to hear it. Cert denied, because the Supreme Court gets to decide what cases it hears. It doesn't have to hear a case if it doesn't want to hear it. Why did they say that? Nobody will ever know. They never explain it. But here's what's interesting. The federal government urged the court to not hear the case. Now, Michigan, in its petition asking the court to hear the case, said, you got to take this. This is going to undermine every registry in the country. If this is going to destroy the whole system. But the federal government said no. Why did the federal government, this is the Trump Justice Department, said no. Why did they do that? Well, we know a little bit more about that because the lawyers for the winners in this Michigan case, Miriam Ackerman and Paul Reingold, two great civil liberties lawyers, they went and met with the lawyers in the Justice Department to find out what they were planning on doing. And you know what I think? I think they thought it was better to sacrifice Michigan than to risk losing the whole ball game in the Supreme Court. Now, why did they think they were at risk for losing the whole ball game in the Supreme Court? Because Justice Kennedy, the same Justice Kennedy who wrote Smith v. Doe, said in Packingham, a case that had just been decided in the month before they had to file this, whether or not they had to tell the Supreme Court whether they thought they ought to hear the Michigan case. Justice Kennedy wrote in Packingham that he was troubled by all these restrictions that were imposed on people who were no longer in the criminal justice system. And he said that in a case in which he didn't have to say anything about that. The case was on a First Amendment issue. And he voted to throw out those restrictions on the registrants on First Amendment grounds. It had nothing to do with this. But he said, by the way, I'm troubled by this. And leaving you with the feeling that maybe he didn't realize what havoc he would wreak by the decision in Smith. So there's a new chance at the Supreme Court. I mean, people sometimes would ask me after the article came out, well, why don't you just, tell them? Well, you can't really do that. I mean, you've got to wait for a case and file a brief in the case. And so there's a case coming up that they have agreed to hear. It'll be heard probably this fall. They haven't set an argument date yet, but my guess is November, maybe December. And it's a case really about a technical issue in SORNA, the Federal Sex Offender Registration and Notification Act, which says it's a federal crime to fail to register. If you're required to register by the state and you don't, you not only probably violate state law, you also violate federal law. So the feds don't have their own registry, but they make it a federal crime for you to not register with the state. Any state you're supposed to register with, where you live, where you work, etc. You guys, I'm sure, know the rules better than you wish you did. So the question is that Congress told the Attorney General when they passed this, well, you figure out whether we should apply this law to people whose registrable offense occurred before 2006. The House and the Senate couldn't agree on that. So for some reason, they just, instead of settling it, they left it to the Attorney General. And that's what they wrote in the law. The Attorney General gets to decide whether this criminal law applies to people whose registrable offense is before 2006. The technical issue in the case is whether Congress can do that. Does it have to decide itself, or can it actually let the Attorney General decide? So not many people in this room care very much about that technical issue. But there's a factual question, of course, that lurks behind it. Those people with pre-2006 convictions, and those convictions may be quite, they can go back to 1990, they can go back to 1980, anything before 2006, are they dangerous anyway? Is there any reason to be having those people register? Well, the government obviously wants the court to think they're dangerous because that justifies the federal rule. And because the Attorney General did decide he would apply it to pre-2006 offenses, and Mr. Gundy, who's the guy whose name is on this case, was prosecuted with an earlier offense, was prosecuted under the federal law for failing to register. So the government wants to think these people are dangerous, which gives us a chance to tell them they aren't. And so Gundy's lawyer is a guy at Stanford Law School. Stanford Law School runs something called the Supreme Court Litigation Clinic. Good work if you can get it. All they do is represent people before the Supreme Court. And Jeff Fisher, who's Gundy's lawyer, has argued about 40 cases before the Supreme Court. And so, but he's got to address these technical questions. And so he asked me, well, would you write an amicus brief explaining the reoffense risk issue? I'd like to have that in there. And in amicus, in case your Latin's not, been recently refreshed, amicus curiae is the official name, and if you translate that, it means friend of the court. And it's what an amicus brief is a brief on behalf of busybodies. It's people who think they have something to tell the court that it ought to know about for some case it's decided, even though I'm not a party to that case, I don't really have any stake in it, but you really ought to know this about what you're about to do. And so you've got to get permission of the court to file an amicus brief. And usually that's not very hard, and we got permission. And so we did a brief, and I got 15 experts we've all together. It's on our behalf. We are the amicus curiae. And they include, some of the most illustrious names in the field, including, I was particularly pleased to get Carl Hansen, who is like Mr. Risk Assessment for sex offenders. I mean, every study there is that's any good deals with Carl Hansen. I mean, he's it. And then there's all these people. I mean, there are a bunch of others. I didn't put up all the names. Anybody, academics would know all these people. This is big time. So that was great. And then we got Debevoise & Plimpton, which is a big New York law firm, that agreed to file this for us pro bono, with absorbing all the costs. And there's costs. You file the Supreme Court. You can't just print out the brief in your home printer. You've got to get it printed at a real print shop in multiple copies and submitted. And I have a copy here. It's really impressive to look at. And it's even, because we put in some of Carl Hansen's graphs, which are in color, it's printed in color. But Debevoise & Plimpton paid for all of it, which is really great. We filed it 2 weeks ago, as I say. The oral argument this fall, we're not, the MECA, I don't get to participate in oral argument. So it's just Jeff Fisher and the government lawyers. And so what did we tell them? Well, you know, we told them a lot, and I wanted to give you a little snippet of it here. But registrant risk profiles, it seemed to us very important to make sure they understood that the risk profile of registrants varies enormously. Many are no threat from the start. Everybody is no threat in the end. When I say now in the very end, none of us are a threat for anything, but that's not what I mean. What I mean is that people who don't reoffend, every moment that they go through life without reoffending, the chance they'll do it in the future goes down, right? And there's this wonderful chart that we gave them. This is one of our little color things. Can I get this? Yeah. Okay, well, you see that black line? I'm going to explain this to you. It looks very complicated, I know, but let's just focus for a moment on the, I'm not sure this is, it gets lost. Oh, my laser pointer gets lost. This black line here, the one at the top, okay, what that is, what that's graphing is for people who are rated by Hansen Static 99 at the very highest risk that they're going to commit, they're going to reoffend, right? Very highest risk. They, over here at the left end of the chart, the risk that they're going to reoffend is about 25%. By the way, I'll just point out, that's the highest risk offenders, it's 25%. Even they're not 80%. The highest risk offenders is 25%. It means 75% aren't going to reoffend, by the way. But, okay. But that's, at the moment that they're released, it's 25%. Then see how that line declines steeply? So this is a recalculation. Assuming that they haven't reoffended, every 6 months you recalculate. Well, what's the chance now that they'll reoffend? And then you recalculate it again 6 months later. And it just plummets. You see how it just plummets. It just goes down and down and down. And this black line here at the bottom is what he calls the desistance rate. That's, if the reoffense probability is below that, there's no reason to think about it at all. And we don't think about it at all with anybody but aside from registrants. And so if you start out at the highest risk, you get there in about 20 years. But so even they get there after 20 years, they're down. And everybody else gets there a lot sooner. And some people start there. You're paying, right? So this is a very important point to make. It's particularly important in this case because we're talking about people who have been out a while in this case. The Gundy case is about people with old convictions who've been out, and they wouldn't be in the case if they'd reoffended. So by definition, all of them are people who've not reoffended since the time they were out. So what we're telling him is, look, we're over here. Nobody, these people are not any threat to anything. And you know, if you try to average the risk and talk about what's the risk of sex offenders reoffending, you average it over all those lines, you can get a number, but the number doesn't mean anything. It's a useless number. It's just completely irrelevant to anything. What you need to know is that most people actually are low risk at the start. Only, you know what percentage of people are high risk in the California registry, which gives people static 99, is about 8%. Okay, so 92% are not high risk. The great majority, or the majority, are the lowest lines, the lowest set of lines. So, I mean, you know, any event. So there's, what's Gundy's potential? Well, it could be decided on technical grounds, and all of our work come to nothing. I mean, they just decide, well, the AG can do this, and we don't really care about the other stuff. Or it might be important. If the government argues that the group at issue here is dangerous, if they put that into, they offer that argument in justification of this requirement, then our brief will become important. We'll see. Either way, it helps educate the court. And there'll be future cases, and maybe we'll plant a seed, even if it doesn't happen in this case, maybe, we'll plant a seed, and it appears that Justice Kennedy at least is open. Just hope he stays there. Okay, now, how did we get to this Michigan case that I told you about, that, where the Sixth Circuit threw out the registry? How did we get there? What gave them the guts to do what they did? Well, it's 13 years, but it's not time to that decision by the Sixth Circuit in 2016 from Smith in 2003. That's 13 years, but it's not time alone that did it. There are a lot of steps in between. There's an enormous amount of work done by the two fabulous lawyers in that case, Miriam Ackerman and Paul Reingold, in building a record in the trial court. These people are on my amicus brief. Half of them were experts in the trial court in Michigan. So they really put a lot of effort into building a great record. That gave the Sixth Circuit a basis for saying what they said. So that was terribly important. But there was also a lot of groundwork laid in state courts, and that's something that's often not appreciated. Mr. Doe of Smith v. Doe, Doe v. Smith, whichever it was, I forget, he understood about state courts because the first state court victory was his after he lost in the Supreme Court in Smith v. Doe. After Mr. Doe lost in the Supreme Court in Smith v. Doe, he went back to Alaska and he renewed the same claim that he just lost in the Supreme Court. And he said it's punishment ex post facto. The Supreme Courts, of course, had said no, it's not. The Alaska Supreme Court said, in Alaska, it's punishment. It's punishment under the Alaska Constitution, because the Alaska Constitution doesn't have to be identical to the U.S. Constitution. So if it would violate the U.S. Constitution, you can't do it in Alaska. But if it violates the Alaska Constitution, you also can't do it in Alaska. Maybe you can do it in Wyoming, but you can't do it in Alaska. And so that's basically what the Alaska Supreme Court said. It said it violated Alaska's own Constitution's ex post facto clause. From 2009 to 2015, look at this list. You've had similar decisions in state Supreme Courts. Indiana, some of these are not where you'd expect. Indiana, Maine, Maryland, Ohio, New Hampshire, Kentucky, Oklahoma. Some of these are not where you'd expect. So state courts matter. I think state courts matter. The gay rights battle and the battle for the right to marry, of course, everybody has heard about the famous Supreme Court decision, and that U.S. Supreme Court decision was preceded by a bunch of decisions in federal appellate courts saying, yes, there's a constitutional right that's being violated when states do not allow gay people to marry one another. And there was at least one federal court that's disagreed. All that happened, of course, before the U.S. Supreme Court decided it. But the first victories for gay marriage didn't come in federal courts. They came in state Supreme Courts in Vermont, in Iowa, and Massachusetts. And the thing is, state courts can't bind federal courts, but they can create a favorable environment. They can create a favorable environment in the law because they put the claim in the legal mainstream. You may say you don't agree with something, but it's a little hard to say it's nuts, it's crazy, it's impossible if 3 state Supreme Courts have said it's right. And so it puts it in the legal mainstream, and it also changes the world in a way, right? It got a little more difficult for people to say the world will end, society as we know it will fall apart, families will all disintegrate if we allow gay marriage, when you have a bunch of states that have allowed it and they seem to be doing okay. And so it's the same principle here. And the Sixth Circuit in Snyder cited these state court decisions in its opinion. Along with all the expert stuff, they cited those decisions. So okay, I've got more time, good. So I want to go back a little about what Alaska said in its decision, because it's been echoed by other states. So I'm just using it as an example since I started talking about it anyway. Why is it punishment? Why is the registry punishment? That was a question the Alaska Supreme Court had to answer. Good, that was it's no good, it's punishment, violates the ex post facto clause. Now, here's the deal. The answer is not it's punishment because it feels like it, right? If that was the answer, a lot of people in this room could be experts in support of that proposition. And obviously it does feel like, I mean, I know it feels like punishment, but that's not the legal test. The legal test for whether it's punishment for the purpose of the ex post facto clause, there's this checklist that court's supposed to go through. And to distinguish a civil regulation, which can be applied ex post facto, to a criminal restriction which cannot. And the registry, Alaska said, flunked a key item on the checklist. The reported, I love this, the reported civil regulation had no rational connection with any non-punitive purpose. Or to put it another way, the only possible purpose of this was to punish. Because it doesn't have any rational connection with any other purpose. Now, punishment doesn't have to be rational, right? I mean, once you've been convicted of a crime, we can punish you because we think what you did was really nasty and you deserve to suffer. That's constitutional. You don't have to have another purpose, but you can be punished for committing a crime. But if it's a civil regulation, it has to have some, and it's imposing a burden on you, it has to have some rational connection to some legitimate public purpose. You can't just pass a bunch of rules imposing burdens on people for no particular reason. And there's lots of cases in the history of the Supreme Court that have said that. So this no rational connection is a very powerful seed. Snyder case in Michigan picked it up. It's a very powerful seed. Now think about, why did the Alaska Registry lack any rational connection? Well, what's the supposed purpose, non-punitive purpose, right? It's public safety. That's the supposed non-punitive purpose. Well, what the Alaska Supreme Court said, and other courts that I've mentioned here, including Michigan, have begun to say, well, the registry can't have a rational connection to this purpose if it's applied to people who don't pose any risk. That seems like so obvious. Which it did, Alaska said. And here's really important. It said because it applied to a wide variety of crimes. It wasn't, they made no effort to figure out who's at risk. Once on, you can't get off. Not of the clearest determination of your rehabilitation, you still can't get off. You can't treat sex offenders as a class. Remember Smith v. Doe, their dangerousness as a class? Because the net is cast too broadly and no one can ever get out of it. That's what the Alaska is there for. That's no good. So this is a very powerful point, I think. This whole notion of treating sex offenders as a class. Rules that lump them all together permanently, I think, are going to always flunk a properly applied rationality test, which puts the registry in question in general for everyone. And the Sixth Circuit in Snyder understood that. Now, the only question before them was this ex post facto question. And the plaintiffs in the case were all people with old offenses who were complaining that these new restrictions were being imposed on them, restrictions adopted after they had committed their crime. So that was the only issue that was really before the Sixth Circuit in Snyder. But they said, you know, we just want to notice that the broader claim that the whole thing is no good for everybody, not just the people from before, is far from frivolous and of great public importance. Those are the Sixth Circuit's words. Far from frivolous, of great public importance. And remember, the U.S. Supreme Court didn't hear this case. They didn't want to hear, they didn't accept Michigan's petition to review it. The Sixth Circuit effectively invited that broad challenge with this language. They basically said, anybody out there want to bring a case? We're listening. And, you know, this might have been not as surprising if it had come from the Ninth Circuit here in the West Coast, which is a very liberal circuit. Sixth Circuit is not that. It's not the worst circuit, but it's certainly, you know, so as I say, the judge who wrote the opinion is a very conservative judge. Okay, well, talking about state courts, what about California? What is the California Supreme Court? Certainly it should be doing something, and it has. It decided a couple of years ago this important case, Taylor, that threw out residency restrictions on parolees that were being imposed down south. Officially, it was a statewide policy, but it was really being enforced in San Diego and Los Angeles. I say down south. My head is still up north where I live in Berkeley, but sorry. But it was being enforced here. And what the California Supreme Court said was, you can't have a blanket rule that says that anybody who's on parole, who's a registered sex offender, automatically has to face all these residency restrictions. You can't do that. You can't impose residency restrictions on that entire group like that. That's what the California Supreme Court said. You have to, if you're going to do a residency restriction on somebody, it has to be justified person by person. And the restriction has to be explained and limited to a restriction that makes sense for this person in that person's situation. So they said the group rule, they said, the California Supreme Court, was unconstitutional because it infringed the parolee's liberty and privacy interests while bearing no rational relationship to advancing the legitimate goal of public safety, and violated basic constitutional right to be free of arbitrary government action. That no rational relationship, arbitrary, those are twins. Things are arbitrary when there's no rational basis for them. So building on Taylor, we have a case coming up. Another case we've done an amicus brief in. This is a really crazy law. Some of you probably know about this law. So this is what the California legislature did a couple of years ago. So there's a mandatory reporting act that makes teachers, doctors, and therapists, and a bunch of other people report to the police if they see child abuse, or they see there's somebody who's posing an imminent threat of harm to a child. That's a standard thing. Every state has mandatory reporting laws. And therapists were subjected to those, so they apply to psychotherapists. And therapists are required to report to the police clients they believe pose an imminent threat to a child. Well, the legislature passed this new law that said, well, the hell with the case-by-case judgment of the therapists. We're just going to say they have to report to the police any client who tells them they've looked at pictures of children. Any client, that's the current law in California, was enacted. So if you are looking at pictures of kids and you're troubled by your own interest in it, and you go seek out therapy to help you deal with it, the therapist has to report you to the cops. That's what the current law says. I'm calling these people lookers. I call them lookers. That's a little weird. It's my idiosyncratic term. But the reason I'm calling them lookers is because what we're talking about here are people with no history of any contact offense, right? They've only looked at pictures, because there are people who've done both. But if they have a history of contact offense, if they're currently abusing the kid next door, the therapist is going to already had an obligation to report that person. So this is what's so crazy about this law. The only effect is therapists must now report individuals they don't think threaten children. Because the other folks they already had to report. So California Supreme Court is going to hear a challenge to this. A bunch of therapists here in LA brought a challenge. They lost. They lost in the trial court. They lost in the Court of Appeals down here. But the California Supreme Court said, we'll hear that appeal. And so they are hearing the case. And we did an amicus brief here as well. And in here I got the law firm of Arnold and Porter, it's another big firm, to absorb all the costs for the brief. Which is, it's really great to have the names of these firms on the brief. It makes it credible. Because these are law firms that these courts know about. These are real major law firms. Debevoise, Arnold and Porter, and major, major law firms. What did we tell them in the brief? In this case, well, obviously, lookers are very low risk for contact offenses. And what's wonderful about this particular group of people is instead of having to just cite academic studies, which somebody can sort of say, oh, these woolly-headed academics, what do they know? You know, who can trust them, right? The best data comes from the United States Sentencing Commission. And this is long-term data. One of the things that gets confusing about reoffense rates, and you can see it actually in that clip too, is a lot of the reoffense rate statistics you see are reoffending within 1 or 2 or 3 years after being released from custody. And that's interesting, but that's not very comforting or, you know, to the people who are worried about this, because they say, well, you didn't catch them in the first year or two, but you'll catch them later. And so what you really need are long-term studies that follow people for much longer. And those are the reoffense statistics that matter. And you do, the proportion who reoffend is more if you follow them for 10 years than if you only follow them for a year or two, no doubt about it. Now, most of them still, who ever reoffend, do so in the first few years, but nonetheless. Well, the US Sentencing Commission followed everybody released from federal prison on a child porn offense over a 2-year period for over 8-9 years, about 8.5 years on average. The US Bureau of Prisons did a study, it's another favorite study of mine. They did a study that said, you know, it was done by some psychologists in the US Bureau of Prisons, and the question was, well, should we be giving therapy to these people? And the answer was no. Why? We can't get their reoffense rate any lower. It's so low already, it's a waste of money. And then Michael Cito is the world's expert on internet sex offending. It's about 2% commit a contact offense. I prefer to say 98% don't. And there are different people with different psychological profiles. Therapists can figure that out. So this claim follows on Taylor. It could build on Taylor, the case I told you about with the parolee residency restrictions that the California Supreme Court decided. Because again, what's happening here is the state is seeking to impose restrictions on a group, not case by case. And here it's a group where the data really doesn't support it. So I think it's got a lot of potential depending on what the court says. You never know. I mean, it's always, you just buy your lottery ticket in these cases. And if you don't play, you can't win. But, but you know, maybe we can win. So imagine if they say, well, lookers are low risk, and therefore this group can't be subject to rules that burden their liberties. But then, can any low risk group be placed on the website? On the registry? If not, what about everybody who hasn't reoffended? They're all low risk. Everybody who doesn't reoffend becomes low risk. And so there's enormous potential here to these principles. It all depends on how broadly the court states them. I wish Jerry Brown would finally fill the damn vacancy. He's had a vacancy in the California Supreme Court for more than a year now, and he just hasn't filled it. So I mean, that may be why the California Supreme Court is still not scheduled argument on this case, even though all the briefs have been in for a while. But I wish he would do it. So back to dangerousness of sex offenders as a class. I think that the very term sex offender, and the groundwork was laid for me this morning by Mary Jo, it's a pernicious term. And if you didn't bring your dictionary with you, pernicious, causing insidious harm or ruin. Ruinous, injurious, hurtful, that's the definition of pernicious. And that's the term sex offender. It's pernicious because it communicates the false idea that these people all share some character flaw that's embedded, that's permanent, it's inherent. That's what it communicates, that very term. It says it's okay to treat them as a group, not as individuals. It ignores the differences among them, and it ignores the differences over time for any individual. It basically, you know, and so it's a terrible, terrible term. So it's a legal category, not a psychological category. That's a really important point. The way it's used, it often sounds like that's a group of people we can talk about who shares. It's just a legal category. The only thing they share is they're on the goddamn registry. Otherwise, they're quite varied. And they're varied, the same person over time becomes a different person. So I've been urging lawyers to not ever use the term in briefs that they file. Don't talk about sex offenders. I say registrant. I mean, it's not ideal. It's hard to come up with a good term. But one thing I like about registrant, it correctly identifies the group by the one trait they all have in common. They share the burden of being on the registry. That's what they have in common. There's really not a lot else, but they have that in common. And it's a legally imposed trait. It's not a psychological trait. So closing thoughts. Maybe frightening and high is really in a death spiral. I think you know, Longo doesn't even believe it anymore. He's not quite willing to say it just directly in the way as I would like, but he pretty much said it. And I think courts are beginning to come around. I think we do better with courts when we have them focus on people rather than sex offenders or any group. Talk about individuals. Mr. Doe, this is a wonderful, you know, this is never mentioned in the majority opinion in the Supreme Court in Smith v. Doe, but Mr. Doe, the same Mr. Doe, he regained custody. This is before he won, before his case was even up in the US Supreme Court. He had regained custody of his minor daughter because the court found him totally rehabilitated, very low risk of reoffending, and he was given custody of his minor daughter. But it's like, focus on what you're doing to him and his daughter. Don't focus on this group sex offenders. Big changes usually come in small steps. You've got to keep remembering that. Decades of small steps before gay marriage came for those who fought that battle. Even longer, much longer, before the end of legal segregation. You know, there's a wonderful history of that battle. And one of the things that Thurgood Marshall, the former Supreme Court justice, who was originally the lawyer for the Inc. Fund, the fund that brought all these cases, that they didn't challenge legal segregation, separate but equal. They didn't challenge that principle like in the first 25 cases. They did not challenge them. They just kept saying, well, this separate here, this separate isn't equal. This separate over here, it ain't equal. This separate over here, it ain't equal. Finally, in Brown v. Board, they said, you know what? Separate can't ever be equal. And it just decades of work to get to that. So small steps. I actually think we've been doing pretty well. Yeah, okay. I also want to say, I focused on successes here, and I don't want to leave you with the impression that we've won every case in the last few years. That's not true. On the other hand, we actually have won cases. We've won a bunch of cases. We never used to win any. And there are some other interesting cases in the pipeline. And I think I'm out of time, so I can't tell you about them. I'll leave you with a tease. I'll leave you with a tease. There's a crazy judge in Colorado. I love him crazy. He was appointed by Richard Nixon to the federal bench in Colorado. I don't know, he was 110. I don't know how old he is. His name is Match. Well, last year he threw out the Colorado registry. He just said, yeah, this makes no sense, no rational connection, blah, blah, blah. Well, that's being appealed to the 10th Circuit, and I don't know where that's going to go, but we'll see. So maintain good cheer and persevere.